So I'm going to talk about the eBay case and its dramatic effects on the law of injunctive relief in the United States. To give some context for the decision, it had been thought for many years that if you had a patent and if the patent was found to be infringed, that you were automatically entitled to an injunction to stop the infringing conduct. And that had a number of concerns where there were other interests, both third-party interests and public interests at stake. And the good news is that although the law in this area, like in many areas of patent law in the United States, had been developed by the intermediate appellate court with almost exclusive jurisdiction over patent issues called the Court of Appeals for the Federal Circuit, the Supreme Court has become much more active in reviewing patent law issues and other intellectual property issues and is restoring more balance to the framework of intellectual property enforcement and to the standards themselves. So without further ado, what we had heard earlier was about the TRIPS requirements. I'll skim over that very quickly. I'll talk a little bit about the traditional four-factor test for permanent injunctions, then talk about the background to this particular decision and the holding in it, and then the consequences that you can see in the cases that have been decided since this case. And then return once again to considering flexibility that may exist in regard to injunctive relief. Again, under Article 44, judicial authorities will have the authority to order a party to desist from an infringement, inter alia, to prevent the entry into channels of commerce. Again, injunctions are not required prior to constructive knowledge of an infringement or in certain cases such as crown use, and they may not be required if it's inconsistent with domestic law. This provides significant flexibility so long as there is a general authority to order injunctions in some cases. That doesn't mean that in any particular case an injunction has to be issued. I'll talk again about why it matters in a minute. So, under the United States law, we have a discretionary injunction authority that complies with the TRIPS agreement, Section 283 for patents, and there's similar language for copyrights and trademarks, which says courts may grant injunctions in accordance with the principles of equity to prevent the violation of any right secured by patent on such terms as the court deems reasonable. Again, this provides tremendous flexibility regarding whether and when to issue an injunction. So, for example, if someone is found to infringe, the court might not choose to shut down the product line of the infringer, but give them a certain amount of time to develop substituted technology, which would then allow them to compete, and they may still be obligated to pay some type of compensatory damages, but they wouldn't end up having significant losses or significant effects on their ability to be market competitors. It has a tremendous effect on the kinds of diversified products. Assume for a minute that you have a small component of your product that is subject to a patent. You weren't sure whether it was. Now you don't have your entire product line shut down until you can develop your new technology that substitutes the small part. It also may have tremendous effects on your ability to engage in R&D. What it clearly has an effect on is the price, because if you are allowed to continue to compete in the market price may not be the monopoly price charged by a patent holder with the injunction, but the competitive price now that you have more than one product. And again, there are significant public interest concerns that may be taken into account, including the ability to provide medical services unrestricted, or the ability to engage in different types of communications activity or access different kinds of information. And again, these effects are not limited to patent law. Traditionally, there is a four-factor test that's looked to for the grant of permanent injunctions. The first and most important requirement is that you have suffered an irreparable injury that cannot be remedied under the second part by monetary damages. Both are important, but they are usually linked, because typically you don't suffer irreparable injury if the defendant can pay for your losses. So one of the reason that you typically get irreparable injury comes with the difficulty of measuring losses or of proving the losses on a continuing basis. The third is the balance of hardships, and Professor Correa had referred to that earlier. Who would be more adversely affected by the issuance of a permanent injunction? And finally, how the public interest would be served by the grant or denial of the injunction. In the eBay case, originally, and eBay, as some of you may know, is an online seller of goods, and Merck Exchange, the patent holder, had sued on the basis of a patent that related to the technology of online selling and the way that the transactions were processed using an internet computer system. The district court decided it would not shut down eBay's entire online auction system, but rather would deny a permanent injunction and allow damages to be paid. There was relatively little doubt that eBay could pay any ultimate judgment. It is true that Merck Exchange might have made less money than they could have if eBay was threatened with being shut down, and then they negotiated a different kind of a deal. And as you'll hear in a second, the leverage that an injunction provides against producing entities is really what this dispute is about. If you don't want to grant the injunction because the patent holder may be able to threaten shutdown, would cost the producer who infringes much, much more than a reasonable amount for a license would normally be. And therefore, the threat of the injunction creates much greater leverage in bargaining, and the grant of an injunction creates even greater leverage in bargaining. The court in the district court in this case was concerned about a number of things. One was that business method patents had questionable validity, but in this case, the particular patent had been determined to have been valid. The courts just don't like these kinds of patents, is the best way to put it. The cost to the court of determining contempt if eBay did not design an infringing substitute, or if it did a non-infringing substitute, if it did design what it thought was a non-infringing substitute, the court would be required to assess whether that substitute avoided the patent, and therefore whether they would be in contempt of the injunction. The fact that the patent holder was willing to license other entities to produce goods under the patent. And finally, the failure of the patent holder to have sought a preliminary injunction to stop eBay, precisely because it increased the amount of damages that could be accrued if eBay was continuing to engage in infringement and infringing sales using this patented technique. Then the patent holder had an economic interest in not shutting them down and forcing them to a non-infringing substitute, but rather in just obtaining a reasonable licensing behavior on a wider range of activity. In the intermediate appellate court reversed the district court's denial of the injunction, and it held philosophically some very important things which the Supreme Court said were just wrong. And the first thing it says is, because the right to exclude recognized in the patent is the essence of the concept of property, the general rule is that a permanent injunction will issue once infringement and validity have been found. And that was, in fact, the way that courts had thought the law operated up until this decision. And as you'll hear in a second, the Supreme Court said that's just not right. Second, injunctions are available to licensors, and the additional leverage that the injunction provides in licensing is, again, a natural consequence of the right to exclude and is not an inappropriate reward. And again, the Supreme Court said, no, we recognize that it may provide in some cases additional leverage that would allow them to charge excessive amounts. And therefore, we need to be careful and concerned about this. It's not a natural consequence of the right to exclude. And again, there's a general rule that a permanent injunction will issue except in sufficiently exceptional circumstances. And given this general rule, that the appellate courts did not say is that the district court had abused its discretion, which typically we think of discretion as very broad. Here it had abused its discretion by deciding on fairly good grounds that there was no warrant for the injunction in this case. So what does the Supreme Court say when it goes up yet to the highest level of the United States courts? It says patent law is not different from any other area of the law. Discretion rests with the district courts to apply principles of equity and to make decisions such as the one the district court did in this case, applying the traditional four-factor test. But the Supreme Court didn't reinstate the denial of the injunction. It sent it back down. Similarly, there are no broad classifications warranted. You have to take each case on its facts. But in some cases, even people who license rather than produce may be entitled to injunctions, and they did not address preliminary relief. There were two sets of concurring opinions. Some judges were focused on the idea that given the history of patent law, injunctions should routinely issue because you can assume irreparable harm. For other judges said that because of the changed circumstances of the way patents are being used, principally as licensing tools, the ability to get an injunction may be too strong and you should not grant them routinely. It went back down to the district court for further determination, and this should say the district court denied permanent injunction on the patent at issue. Most importantly, said there is no presumption of irreparable harm from the violation of a patent. You have to look to the actual facts of the case. And in this case, although there might have been some loss of market share or brand name recognition or goodwill, it was not sufficiently severe to adversely affect the balance and tilt in favor of granting the patent holder the right to enjoin competition. Similarly, the court said the basic interest of this particular patent holder was in obtaining licensing revenue, and therefore there wasn't an interest in protecting the ability to sue people to get higher licensing revenues, but merely to use the patent to obtain licensing revenues, and the court can decide what is reasonable, as had been done in the case itself. As a result of the eBay case, you now see a much wider spectrum of cases, some grants, some denials, both in the preliminary and in the permanent injunction context. Although it's interesting that you tend to get more grants in the context of permanent injunctions and preliminary injunctions, as you would expect. The preliminary injunction considerations are similar but not identical to the permanent injunction factors. The most important issue is the question of how strong a showing do you need to make regarding invalidity to deny an injunction, and whether the presumption of validity that a patent has simply by it being granted should be a factor when you consider whether to issue a preliminary injunction. And again, whether the defendant would be solvent to satisfy any loss of market profits that might result, including there is a doctrine called price erosion. If you go from a monopoly price to a lower price, the patent holder can prove that they have lost money on their own sales through price erosion. Again, copyrights and trademarks, we're seeing a wide spectrum, but again, fewer grants than you would have had before eBay, and in particular, though, you tend to get a permanent injunction in trademark law to protect the consumer interest in not being confused. And the rules are not yet been fully determined, but we're starting to see patterns emerge in the exercise of judicial discretion. I'll conclude with this because these are areas where civil law systems, rather than leaving it to the judges to develop on a case-by-case basis, could start to develop written rules of their own regarding how injunctive relief should or should not apply in various circumstances. And distinctions are being made between people who sell, so-called practicing rights holders, and those who only license. Distinguish between patents that have important third-party effects, access to medicines, access to communication technology, distinctions based on whether or not it provides so much leverage and royalties that the patent holder will get too much money through the threat of an infringement action, and distinctions between the relationship of the rights to the actual products being sold. Finally, relationships based on when the injunctive relief is sought. The important thing to emphasize, therefore, is that even in the United States, there is tremendous flexibility that is being recognized in regard to judicial discretion and how it's exercised that develops over time into a series of rules. Developing countries can choose different rules than the U.S., and they can choose rules that might emphasize other considerations, such as cost to the public, other kinds of public interest, high prices, various other issues that might be of greater concern in those countries than in the United States. I'll stop there. Thank you.
Thank you very much, Professor Gonzalo. I think you have chosen a very interesting subject for the presentation. We know United States